Such a pleasure to be joining you right here on the India Development Debate on ET Now. I'm Supriya Shrinate, and the Rafale rout doesn't seem to extinguish. A day after the newspaper Hindu reported that TND executed a costlier Rafale deal, and of course the matters exploded in the Supreme Court. The Attorney General evoked the Official Secrets Act in the Supreme Court, stating the documents were stolen. Opposition leader Rahul Gandhi today did say that the Prime Minister should be facing charges. Finance Minister Arun Jaitley hit right back, stating that no dynast can claim that he or she is above the Supreme Court and the CAG. Jaitley also said that the allegations made by Rahul Gandhi against the Prime Minister were unfounded and absolutely shameful. The opposition, though, is relentless in its quest to get the review done on Rafale. Is the government now on a sticky wicket? Is there something to hide? Is there time come for the Official Secrets Act to be repealed? Can investigative journalism be at the hands and suffer at the dole-outs of press releases? This is exactly what we're discussing right here on the India Development Debate this evening. Joining us is a special panel right here. Hitesh Jain, spokesperson of the BJP. Adil Singh Bopara represents the Congress Party. Kalajay Shukla is a senior journalist and a strategic affairs expert. And of course, his voice matters a lot on this debate. Vikas Singh is president of the Supreme Court Bar Association and former additional Solicitor General. And of course, Abhijit Iyer Mitra, Senior Fellow at the Institute of Peace and Conflict Studies. So thank you very much, all of you, for being with us. And before I move any further, Ajay Shukla, if I may ask you, amidst a very heightened national fervor and all of that, has Rafale once again come back to take center stage of the country's political narrative? You had what happened at the Supreme Court yesterday. You had Rahul Gandhi do an early morning press conference, a very sharp retort coming in from Mr. Jaitley amongst many other ministers. Is Rafale back on center stage?
Oh, well, these are, Supriya, all going to be political issues in the election campaign for 2019. The Rafale is going to be a politicized issue, just as the airstrikes into Pakistan and the Indian pilot and his return to India. National security and national security issues are, in this particular election, going to be unprecedentedly center stage. Is this good? Is this bad? We don't know. It's good in a way that national security issues are being discussed. However, I would say that they are not being discussed in the right manner. Nobody is really keen on getting down to the nitty-gritties of the issues and explaining them to the public. It's more and sort of a platform for name calling between parties, which is not good. It doesn't mean that anything good will come out of it, or any reforms or measures to improve our national security procedures will come out of it. It just means that it will be a sort of an issue where both the opposition and the ruling party will use it for hurling allegations at one another and to cite each other and to call each other anti-national and people who sink Indian national interests. That's not good.
Okay, fair point indeed. We will perhaps never get to the bottom of where the problem in defense procurement lies, and there will be allegations hurled at each other, but such are times. And Vikas Singh, if I may come to you, how concerning is the fact that the Attorney General tells the Apex Court that files in Rafale have been stolen, and those are the files that are being reported from? A, how grave a charge is that? And B, how big a lapse is this on the part of the government itself? Does this in any way raise the uncomfortable doubt that there are things that the government is on back foot for? I mean, people are saying, is this too much of a coincidence that when the needle is being directed at the PMO, the file goes missing? Is the government here trying to hide something?
Well, I definitely feel that the government is on the back foot. And if you just go into this perspective, into the background of this controversy, the Official Secrets Act was enacted in 1923. Now, we have come a long way since then. We have the Right to Information Act enacted in 2005. And now under the Right to Information Act, virtually you can get every document unless the document is relating to some investigation in some crime, etc., which needs to be kept back from anybody seeking disclosure. So if you look at the scenario today, to still rely upon the Official Secrets Act on documents which can't be said to be of such a nature that they are, sovereignty or integrity of the state is concerned, it's ultimately a commercial transaction. A contract has been awarded, and in the awarding of the contract there are certain discrepancies or certain decision making flaws which the petitioners are wanting to bring out. Now, if you say that there is a crime committed in the disclosure of these documents under the Official Secrets Acts, then there is also a crime committed by the government of perjury by not disclosing these documents on its own to the Supreme Court. Because when you come to court, one of the fundamental principles of any adjudicatory process is that you should make a complete disclosure. Now, if there was something in the matter of selection of the Rafale planes and there was an issue which needed to be disclosed and which the government is now trying to say that it has been stolen and being disclosed in this manner by this review petition, then I don't see why the government itself did not disclose this information if it was already there. So, it's not as if they are saying that something has been fabricated. It is not as if something that they are denying the existence of these documents. They are merely taking shelter to this very old act of 1923, which really to my mind has really been diluted to quite an extent with the promulgation of the Right to Information Act. So, the Attorney General will definitely have to meet the questions of the court that what was the decision making process and whether it was flawed in any manner or not, and he can't take just shelter of this Official Secrets Act and try and divert the attention of the judges.
Okay. Okay, Vikas Singh, give me a minute because I want to take that question straight across to Hitesh Jain, who represents the BJP here. And Hitesh, even if we were to agree for a minute that this is stolen, what about what those documents say? What about reports which are allegedly based on that document that are coming out? Nobody is talking about whether those, that's genuine or fake. And like Mr. Vikas Singh said, you can turn around and say that this breaches the Official Secrets Act, or you can face perjury for not bringing it to book in the first place. Why is the government quiet on the veracity of what those documents apparently allege?
Supriya, since the matter is sub judice in the court and Attorney General is already arguing before the court, so let's leave the issues to the Attorney General and the court to take a call on the document and their veracity and this thing. But I want to make one larger, broader point. Now, even if you look at the way our constitution was drafted and the frame, when we look at the debates in the framers of the constitution, when they debated, when this whole constitution was drafted, one of the exceptions that was carved out was national security. Yes, there is a freedom of press. Yes, there is a lot of freedom available. But whether it is your right of RTI or whether it is your freedom of press, the exception to that is national security. And obviously what we have noticed in the past few days, that if the documents have been leaked and if those documents could not have found in some people's hand and it has landed someplace, then of course we must know what is how they have been leaked and what is the source of the leak. There was an opportunity for Mr. Bhushan also to explain the source. The fact is he has not explained the source. And what is baffling nowadays, and today we saw a live example in the Supreme Court when Mr. Bhushan himself admitted in another matter pertaining to the appointment of the CBI chief that he spoke lies about fabricating of document and he has admitted his mistake. So
no, he did not say that.
Like Bhushans are representing,
okay,
they rely on the stolen document. They brazenly lie. He has accepted to the court. So one must go to the root of the whole issues. Nothing wrong.
Why are you mixing two issues here? No, don't mix two issues here. And I think my only submission is
mixing
that
the
if
issue.
it has
Mr.
not,
Bhushan
if it has
is a
been
common
stolen,
factor
then why
everywhere.
did the government
The fact is Mr. Bhushan is the common factor.
So why did you not bring it to the court's notice in the first place is a question that many people will ask. Why was it not brought to the court's notice in the first place? And the government will have to answer that. That's all I'm trying to say. But Abhijit Iyer Mitra, before I go to the Congress, I have a direct question for you. An investigation, of course, has apparently been ordered into the stolen papers under the Official Secrets Act. I'm going to understand the due process of law from Vikas Singh, but what does this tell you about, how does this exist and coexist with the RTI? How does this coexist with Article 19 of the freedom of expression? What does this do to investigative journalism? I mean, what is journalism today going to rely upon? Press releases? Is it wrong to report questions that should be asked and must be asked in the public domain?
Look, there's several aspects to this. The first thing that you're asking is that is it the freedom of expression parts of the Constitution, right? That's completely separate, because freedom of expression is within the limits of the law. My freedom of expression, as far as I interpret it, could be to go bash somebody I don't like. But you know, there's that saying that your rights end where my nose begins. And that's what we're talking about. Governments have to function, they have to keep secrets, and there have to be laws protecting those secrets. Because if this keeps going on, you can pretty much say, well, why do you need classified algorithms, jamming algorithms and all of that? Let's just publish it all out there in scientific papers and so on and so forth. So we have to understand there's several different legal issues that we're conflating out here. One is government secrecy, and the second is how do you breach that in genuine public interest out here? Now, the Official Secrets Act is, what it does is, it basically punishes people for leaking classified documents. Now, it is up to the courts to determine, it is up to the courts to arbitrate what constitutes a leak and what constitutes the public interest out here. It's a very fine balancing act, and the courts decide that. That said, remember that even if it is in the public interest, once a document is marked secret, to allow every officer to, you know, have an attack of conscience and go around leaking documents, governments can't run this way. Governments can't run on conscience, they have to run on law. And the law is very clear that these documents were marked secret, and their leak therefore fundamentally constitutes a treasonable act under the Official Secrets Act. And it has to be prosecuted to the maximum extent of the law. I'm just hoping that they actually catch the person who leaked these documents, because, you know, like Yes Prime Minister, which, whether you believe it or not, actually contains more truth about governments across the world than we would like to believe. The whole of government is like a sinking ship. It leaks like a sinking ship. And we have to understand that the prosecution happens at the supply side, not at the demand side. Everybody demands classified documents. It is not the demand side that needs to be punished, it is the supply side that needs to be punished.
Okay, fair point, fair point. And I'll go across to Vikas Singh in just a bit to understand what are the legal ramifications if it is indeed established. But I will have to go to the Congress at this stage. And the Congress is demanding, and again this demand was renewed today by a party president, that the Prime Minister must be probed, that charges must be pressed. The question is, where is the evidence of any quid pro quo? I mean, yes, you've established, yes, there may be something murky in the deal, but there is nothing that is leading to the Prime Minister just yet. Nothing at all. I mean, simply saying Anil Ambani is not going to put him under the lens.
Well, Supriya, the Prime Minister has been caught red-handed, and the entire Sangh Parivar machinery is working overtime to shield him. Let's be very clear, this is a brazen act of corruption. And I would urge my friend who's a defense expert to read the judgment of the US Supreme Court in the Vietnam case. Similar arguments were made by the Attorney General for the US Supreme Court, but the US Supreme Court, and I think the underlying principle extends to India as well, that the public has a right to know, because ultimately this is public money, this is taxpayers' money. There are serious issues. The government has misled the Honorable Supreme Court. The government in their affidavit and in their response to the Supreme Court said that the PMO had nothing to do with the negotiation process. Now, the Defense Secretary's own note demonstrates that the PMO was directly negotiating with the French, and they weakened India's position. The anti-corruption clause was removed. The Law Ministry insisted on a bank guarantee. And I think my friend who's a defense expert will agree that world over bank guarantees are insisted upon, because this is the only via media through which public money can be shielded. In the Augusta case as well, the moment there were allegations, the government of India invoked the bank guarantee clause and they protected public money. In this case, at the behest of the Prime Minister, the requirement for a bank guarantee was waived. If you go further, what special capability or caliber did a 12-day-old company demonstrate to Dassault? Anil Ambani, who's a bankrupt crony with zero prior defense experience, is given $1 billion contract in defense manufacturing, obviously warrants an investigation. The entire deal is shrouded in secrecy. The government is hiding behind the shield of national security. There are skeletons tumbling every day. Why is the Prime Minister shying away from an inquiry? I just don't understand. There are allegations of cronyism. There are allegations that his office in the NSA, who has nothing to do with the as per the DPP, with the negotiation process, is holding parallel parleys, is weakening India's position. And why is the Prime Minister silent on this?
Okay, Adar Singh Boparai, Adar Singh Boparai, give me a minute. One can question the Prime Minister's silence, but there, like I said, there is still no quid pro quo that has been established. There is no evidence. But Ajay Shukla, I'll come to you. And reports based on these documents or otherwise seem to allege that there were 3 domain experts of the negotiation committee who were undercut by a parallel track that the Prime Minister's office and the NSA were carrying out on Rafale. My simple question is, without trying to, talk about press charges and all of that, does this raise questions on the integrity of the decision-making process, that you had experts who were left out and undercut?
Well, it certainly raises some questions, and let's look at what those questions are. The first question it raises is that there is a dissonance within the government itself, where one branch of the government, namely the PMO, is undercutting and overruling the other branch of the government, which is the primary branch of the government dealing with this particular Rafale issue, which is the Ministry of Defence. So in that there is no question. Even the 3 people who objected to all of this have put it down on file that they have a problem with this. That has been well established. Now the question that then comes in is, why was the PMO doing this? And here is where the Supreme Court needs to ask certain questions. Was it because the PMO just wanted to control things on its own? Was it because the PMO thought the MOD was completely incompetent and unable to do it? Or was there an ulterior motive, which was a financial motive? And if there was a financial motive, was there a channel of payment or any sort of indication that there could be payments routed in order to influence this decision? And according to the petitions filed in the Supreme Court, according to a lot of allegations that are made, that route exists. That route was created through the offsets route, where New Delhi, apparently according to French President Francois Hollande, insisted on a particular industrialist being the beneficiary of the offsets. So there is a malified, or I should not say the word malified, but a sort of a non-procedural decision-making line that was created. And at the same time, according to these allegations, there was a channel created for benefits to flow to unauthorized parties. So there is absolutely, in my opinion, a cause for investigation, a cause for examining these issues. Anybody who says that there is no indication of wrongdoing is simply shutting their eyes to the realities of this case. I think there is plenty of indication of wrongdoing, and the Supreme Court should go into it and sort of override these objections of national security, because as they say, the last recourse of a scoundrel is national security.
Oh, absolutely. And we've seen that happen time and again in our own history as well. But Hitesh Jain, I'll give you the option to respond to and refute, if you may want, to what Ajay Shukla has said. I think some of what he has said carries a lot of water, that, in the name of national security, you can't turn a blind eye to questions that are being raised. Why were there parallel tracks of negotiation that were happening, which is being established? And the second question that I may have to ask you is that, given the fact that we had a MiG fight in F-16, which should never have been mentioned in the Supreme Court in the first place, but given the fact that we had a MiG fight the F-16, we need small aircraft today, which is even, the reality is looking and biting us in the face even more. Why was, then we come back all to the basic question, why did you reduce the offtake from 126 to 36? You could have gone ahead with 126 in the first place, given there is such a dire need, which is now being raised by the Attorney General himself in the Supreme Court.
Well, let me explain you this point by giving you one more illustration, and that will also explain the point which Ajay made. In 2009, the Defence Ministry officers and the request from the soldiers was the demand for 1,86,000 bulletproof jacket, and they wanted then and there. So someone in that ministry, so again the typical thing, one of the officer from the Defence Ministry said, oh, the order was finalized, oh, there is a scam. And as a result, what happened? between 2009 to 2014, not a single bulletproof jacket was purchased. It was a contract of 639 crore. And finally, when our government came into power, we placed the order not only for 1,86,000, but in excess of 2,25,000, and everything was procured and everything was all fine. The idea was that if there is a desire to conclude the contract without getting into this thing, the point that I am making is that there will be so many objections, there will be this thing. One has to look, and at that time it was noted by UPA on the floor of the house in the reply to one of the questions in the parliament, oh, there was a corruption we were sensing, and both from 2004 to 2014 it was a UPA government. That is one point. Second point, from 2004 to 2014, Congress has been always tom-toeing that we have a contract, we had a cheaper deal. Then why did you not close the contract? I mean, yesterday Mr. Anthony said that we protected the national security of India by not purchasing Rafales. Now, I'm baffled with the kind of logic and explanation, and that is the reason, and that explains when you're exposed, that you have compromised with the national security of India. Then Rahul Gandhi nowadays, he is suffering with the LCD syndrome, that is L for lies, C to confuse, and D to deflect. So when you are caught confused on the national security,
no.
compromised
Let's
with the
not
national
belittle.
security,
No.
then you
I am
can
not
have
going
this
to
kind
allow.
of explanation. Oh,
Hitesh.
this kind of this thing. The fact is, Supriya, let's make it CAG. We have the CAG report. We have the Supreme Court has examined all the aspects, the decision-making process, the prices, all these allegations which are being made are afterthought. And even if one looks at the document, it doesn't shows any scam. I mean, people can raise a stink if they want to raise.
I'm not so sure because I haven't seen the documents.
Hitesh Jain, even if you look at the documents, it doesn't raise any stink.
No, okay. Hitesh, I think the Supreme Court took its first decision on an erroneous response that was given by the government in a sealed envelope. It wasn't even an affidavit, it wasn't signed by the government. The CAG report came much after.
The
CAG report apparently doesn't even talk about the bank guarantee.
So, offset contract,
so how was it tabulated? But anyways, give me a minute. Give me a minute. No. Hitesh, please wait. I'm going to go across to Adil Singh Boparai. I can puncture 10 holes in the argument that you made. But the one thing that you said was right, which is why did the UPA not ink the deal? And today, AK Antony says, I did not do the deal in national interest. You can't hide behind inaction and take a high moral ground. And because the reality is that the Indian Air Force has, ammunition which is obsolete, the delay was too long, and which is perhaps why the deal needed to be expedited, just to be the devil's advocate. Adil.
Well, Supriya ji, the BJP follows the 3D policy of deception, division and distortion. Let's be very clear. Nobody has ever questioned the quality of the jets and the necessity to have these jets. Now, as per the RFP and as per the process, the bids were finally opened up in 2012 and the Rafale became the L1. There were checks, there were checks carried out, there were accessories which were required for India's specific conditions. All that was done, and had we come to power, the deal would have been inked. But here there are legitimate issues which have been raised, and I again reiterate those issues. If the Law Ministry has insisted on a bank guarantee, and it is a standard format of all international contracts that you secure a bank guarantee in the event of any kind of default, why did the Prime Minister's office had to waive this condition? Isn't this a concession which is being granted to Dassault? Now, the BJP makes a lot out of the fact that, well, this is an intergovernmental agreement. The fact of the matter is that the money is being paid to these two private companies. So the BJP should not deceive the country by saying this is an intergovernmental contract. And most importantly, what was the need to remove the anti-corruption clause from this agreement? The Prime Minister, day in and day out, tom-toms about na khaunga, na khane dunga, and then in a 60,000 crore rupee contract, removes the anti-corruption clause. How does this sit with the rhetoric? How does this sit with the law? And today the BJP is talking about secrecy, it's talking about OSA to intimidate the press. Let me tell you, this is going to backfire. And for the purposes of an investigation, all what is required at this stage is an offence which discloses facts which disclose the commission of a cognizable offence. And if you look at the material in totality, I think that basic threshold is clearly satisfied, which needs an investigation, a comprehensive investigation.
Adil, I have to come in there.
Inquire into the role of the Prime Minister and the NSA.
Okay.
The NSA had no business to interfere in the deal.
Okay, Adil, please give me a minute.
The DPP.
Okay, Adil, please give me a minute. I will have to go across to Vikas Singh because everybody is okay. Either you can talk or I can talk. We don't do debates like this, and you've known that. You've been with our channel before. Mr. Singh, there is one question that's coming once again back and back. The Official Secrets Act and its violation. The reality is that neither of these two political parties have repealed it, and they can take the high moral ground today. Now, Section 6 of the OSA 1923 states that information from any government office is considered official information, hence it can be used to override RTI considerations. But hasn't the time also come, given we have an RTI, given there is a Section 19 and all of that, hasn't the time also come? And the second, if I'm not wrong, the second Administrative Reforms Commission has said that the 1923 OSA that was largely meant to serve the interest of the British must be repealed. The reality is that neither of the two sides of the political spectrum have done that, and they're willing to take a high moral ground on this, whether it's the BJP or the Congress.
Well, if you see the Official Secrets Act, the main section is Section 3, which is penalties for spying. Now, this whole act actually, it may have been termed as the Official Secrets Act, but there is no definition of an official secret in the entire act. And the charging section is penalty for spying, and the spying is basically, if you look at that section, it is as if you are getting into areas which are prohibited, or taking documents which are for the purposes of being given to the enemy. So those are the kind of cases which are being referred to in this act. So this act is not actually, really speaking, an Official Secrets Act. It is more an act for punishment for spying. So this is not one of those cases where you can say that this is a case for spying, or this documents which have been used was actually meant to be given to the enemy, or these documents were meant to compromise the integrity of the state or sovereignty of the state. This is a case where the review petitioners are saying that if there was some material with you questioning the justification for buying Rafale, and it was the expert opinion, then when you overruled that opinion, you should have been candid to the court and said that this was the opinion, but for this reason we overruled. You may have had good reasons. Nobody is saying that you don't have good reasons or you can't have good reasons. The fact that you didn't disclose this to the court is actually a case of perjury, which is inviting with 7-year sentence. So whoever has not disclosed this to the court can be also hauled up for perjury. So really speaking, it may be loosely said as an Official Secrets Act because the nomenclature of the act says so. But when you read the act in totality, or give a holistic view to the entire act, the act is not actually an Official Secrets Act. It's an act basically against spying. So this can't be said to be something which can be said to be spying. This can't be said to be a case where, and best part is that the government has not denied these documents. So there is a report, there is a committee which had given certain recommendations.
That's exactly my point.
Which say something contrary to what the government has said,
right,
as far as the justification is concerned. So they'll have to actually deal with that. I mean, they're just deflecting the larger point by getting into the legalese.
Right,
they're basically, threatening the petitioners that you will go to jail under the Official Secrets Act and trying to scuttle the hearing in that process, which is very unfortunate. I'm really unhappy that the attorney has gone in this line rather than meeting the point head on.
No, and actually there's another thing that makes me unhappier. And Abhijit Iyer Mitra, if I may ask you this question, isn't the Attorney General to be blamed for invoking nationalism to beat down the Rafale narrative? I mean, is he justified in saying that we need Rafale to push away F-16? This issue has nothing to do with the case. It is almost emotional blackmail during heightened national fervor. And then, of course, he goes on to say that every single sentence that the court is going to say will be used by the opposition to destabilize. There is almost an attempt to tap into the national fervor, which is very heightened, and to fearmonger.
Right. So let's be clear about one thing before we start, because I'm going to answer your question and because it ties into a lot of the points made before this. First of all, let's remember, if you read the Hindu story today, they haven't actually published pictures of the relevant documents, because it's been conclusively proven that the documents that they did publish were heavily digitally manipulated, almost to the point of forgery. Second, we need to understand that what KK Venugopal, if the government wanted to invoke the OSA, they would have already done it by now. KK Venugopal, lawyers generally tend to threaten things in court. That's how the thing moves. And that's what it is. Ultimately, I can't answer for KK Venugopal because it was a fantastically stupid thing that he said. You know, there is a point to be made for nationalism being used to hide critical information. Like Ajay Shukla said, you know, national security is the last refuge of a scoundrel, which is why I don't think we should make KK Venugopal's argument the thing that everything else pivots on. Understand this, the gentleman who spoke after me talked about the Vietnam case. I would urge him to Google a lady called Judith Miller. She was convicted in the, she was thrown in jail in the US by a court for naming Valerie Plame as, outing Valerie Plame as a spy. So understand rules and procedures, you can't just go around outing everything like that, right? America, Obama prosecuted more journalists, Barack Obama, mind you, not Donald Trump, not George Bush. Barack Obama prosecuted more journalists for violations of the OSA, put more journalists under surveillance than any other president before him ever had. PMO interference, understand. Things like sovereign guarantees and so on and so forth have much larger implications. That doesn't mean the PMO is interfering in a particular case. It's sovereign guarantees. Now, bank guarantees, one other thing. Look at all the deals we've done with America and Russia to date. They haven't come with bank guarantees. They haven't come with sovereign guarantees. So what sovereign and bank guarantees are you talking about? Which means basically every deal with America and Russia is a corruption-prone deal. That isn't the way it works. I think we really need to start separating chaff from the wheat out here, because there's a lot of really pedestrian third-rate arguments being forwarded which really don't hold up to any kind of scrutiny.
Okay. Abhijit Mitra, I'm going to end the political fervor there, but I want to get back to a technical part of the question. Ajay Shukla, I think it's only fair that you answer this one. And you know, this is a question that I could make my peace with, and which is why I'm forwarding it to you, because there are two sides to this argument and both of them seem to fit well. There are people who have said that HAL that made Mirage, which dropped the bombs, was good enough to make those Mirage. HAL did manufacture the MiGs that could bring down an F-16, and suddenly HAL was so inept to make the Rafale. So that's one side of the argument. The other side of the argument, of course, is that people have questioned the competence and the declining competence of HAL over the years. How are you going to marry the two arguments? How do these two settle in together?
Are you asking me that question, Supriya?
Yes, Ajay.
Okay. Yeah, there's a lot of obfuscation going on over this business of, you know, whether the Rafale was essential for shooting down the F-16 and so on. Let me put it absolutely clearly down before our viewers. The Indian Air Force has bought several planes specifically for the purpose of countering the F-16. The Mirage 2000 was bought at a time when Pakistan had just got the F-16, specifically to counter the F-16. The MiG-29 was next bought specifically to counter the F-16 in air-to-air combat. The Sukhoi 30 then came into service. One of the big reasons for that was to have an overpowering air dominance presence over the F-16. The Tejas fighter has come into play after that. So with all these aircraft in the Indian Air Force's inventory, to argue that now we need the Rafale and only the Rafale is going to be able to counter the F-16 is disingenuous, to say the least. It's an insult to the intelligence of anyone who knows anything about the Indian Air Force, and I'm surprised the Attorney General resorted to a ploy like this. But it certainly doesn't stand factual water. The other point that I'd just like to briefly counter is the one that Abhijit made just now, that contracts signed with Russia and with the United States don't have bank guarantees and don't have sovereign guarantees. This goes to the heart of the definition of a sovereign guarantee. When you've signed a contract with the United States government, there is an automatic sovereign guarantee attached to that contract because the sovereign has signed that contract. So you don't need a separate sovereign guarantee. The fact that the Pentagon has signed the contract, or Rosoboronexport, which is an arm of the Russian government, has signed the contract, means there is a sovereign guarantee attached to that contract. And the reason why you don't have a bank guarantee with America and Russia is because you have that sovereign element. In the case of France, what the PMO did was to remove the element of both sovereign guarantee and bank guarantee, leaving the Indian side with very little to hold on to in case Dassault didn't deliver on its promises or its contractual requirements. So there's a big point to be understood over here. The sovereign guarantee and the bank guarantees cannot be dispensed with just like that, and the PMO did the French side a clear favor by doing so.
Right. Right. Okay, fair point indeed. I've got two quick last closing questions, and I think it's only fair that I go across to the politicians on the show. And Hitesh, in fact, before Hitesh, may I first go to Adil. And Adil, you know, there was Pulwama and then there was the Balakot airstrike, and you know, it almost seemed that the government has wrested the narrative away from the opposition. It was on a back foot before, but it seemed to be suddenly in the driver's seat. Is this also the opposition's attempt to get the narrative back, to put the government on the back foot so that the BJP can't eye the rich political dividends it was out of the airstrikes?
Well, Supriya ji, a preliminary point, the fact that the BJP is not responding on the merits of the allegations and is not doubting the authenticity of the documents and instead is putting out proxies to put forward their case by itself is very telling. Now, coming to your question, let's understand Mr. Modi is ace when it comes to headline management, but this problem, this strategy of his, it always comes with the problem of diminishing returns. He has certainly failed on the economic front. He has failed to fulfill his promises. Now this is an attempt by Mr. Modi to divert public attention, but he will certainly fail. Today unemployment starts at 7%. Today farmers are committing suicides. There's a 10% jump when you compare this with the UPA years. So ultimately the people of this country are going to ask him those hard, pertinent questions. But coming to the Rafale issue, I think the Congress party has right from the starting flagged several concerns. There are several contradictions in the government's position. And coming to the issue of parallel negotiations, I think it's very important that this is not a charge which is coming from the Congress or the other opposition parties. The Defense Secretary of this country on an official note says that parallel negotiations are weakening India's position. I think it speaks volumes of the manner in which this deal has been proceeded with. And we all know that there is an escalation in the price of the jet. And given that bank guarantee has been waived, given that the anti-corruption clause has been waived, I think the Prime Minister cannot hide behind national security for far too long. The people of this country are intelligent, they are enlightened, and they will certainly hold him accountable.
Adil, I'm sorry. Okay, Adil, I'm sorry, but I'll have to cut you short there and I'll have to give the last word to Hitesh. And Hitesh, you know, many people believe that the big political issues were going to be joblessness, were going to be the farm stress, and suddenly, you know, this happened and people believe that the narrative did change, and it did, you know, it would have accrued electoral and political benefits to the BJP. But now we see Rafale come back on center stage. How are you going to ensure that you wrest the narrative away from the opposition and stick to what works for you?
Well, we don't need to do anything. Today, one of the senior leader of the Congress has made a statement that Pulwama and Balakot is a match fixing between India and Pakistan. So when Congress and their track record on national security, everyone knows. I mean, India is debating what was the response of the Congress during the 2004 to 2014 and what was the response of this government when it comes to the issue of national security and the kind of loose comments which the Congress leaders can make. Such statements can make them heroes in the eyes of people of Pakistan and get them TRP in Pakistan, but in the eyes of the people of India, they certainly look like big villains. We don't need to do anything. Congress will do our job. They will continue to making such loose statements, and people know their track record very well. So as far as we are concerned, we had the narrative before also, before 6 months also, and we have the narrative now also. Even on the front of the development, we'll debate with them.
I wish, okay, I do wish and I pray that one day in Indian politics, no matter how ugly it gets, the two sides are not going to call each other agents of Pakistan. This is a law that Indian politics must at all cost avoid, and I think politicians will be ill-advised to gloss over the temptation to not do this. Thank you very, very much, gentlemen. Ajay Shukla, Vijay Singh, Abhijit Iyer Mitra, Vikas Singh, sorry, Abhijit Iyer Mitra, Hitesh Jain, and of course Adil Singh Boparai. Thank you very much for being with us on this edition of the India Development Debate. We take a quick breather. We come back and put the spotlight to where the truth really lies, and that is jobs. We discuss jobs with Mahesh Vyas in a moment from now.